Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 14 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we are covering cases decided between September 16th, 2020 and September 21st, 2020. We will start this week with two civil litigation cases. Garwood v. Ameriprise is an appeal following a jury trial where the jury found in favor of Ameriprise. The Garwoods had purchased a life insurance policy from Ameriprise. As they aged, the monthly payments began to increase. They eventually surrendered the policy and sued under various theories. After losing at trial, the Garwoods filed a post-sentence motion raising two issues, the first addressing the weight afforded to Mrs. Garwood's testimony, the second involving a statute of limitations claim. The post-sentence motion was denied. On appeal, they raised 5 new issues, including a sufficiency of the evidence issue. The court found that all appellate issues were waived as they cannot be raised for the first time on appeal. The court noted that they attempted to play appellate gamesmanship by swapping out a weight argument, which the appellate courts cannot address, for a sufficiency argument. The court was not persuaded by their argument, and the appeal is dismissed as all claims were waived. In the case of Nicole B. versus the Philadelphia School District, the court considers the equitable tolling principles in the Pennsylvania Human Relations Act, or the PHRA. The underlying facts of the case are not in dispute. Appellant's then 8-year-old son was harassed at school, and months of physical and verbal harassment led up to a sexual assault in the school bathroom. The boy was removed from the school after his mother learned of the attack, but an administrative complaint against the Philadelphia School District was not filed with the Human Relations Commission until 2 years later. The suit was rejected as untimely because the PHRA has a 180-day limit for filing a complaint. Pennsylvania also has a minority tolling statute, which tolls the limitation period for a minor, generally stating that the limitation period does not begin until the minor reaches majority. The question here is whether the minor tolling provision applies to this case and whether the general provisions of equitable tolling apply. The doctrine of equitable tolling extends a statute of limitations when a party, through no fault of its own, is unable to assert its right in a timely manner. Equitable tolling is also a malleable, policy-driven concept, taking into account principles of justice and fairness for both the party who seeks delay of the running of the limitations period and the party who is protected by the statute of limitations. The primary purpose of the PHRA is to address, prevent, eliminate, and remedy unlawful discriminatory conduct. The court found that denying minors the right to be heard by the Human Relations Commission and to recover for wrongful discriminatory conduct through an overly restrictive interpretation of the phrase equitable tolling would defeat the very purpose and policies upon which the PHRA is based, and indeed would severely undercut the protections of this humanitarian statute. In conclusion, the court found that the PHRA's equitable tolling provision is ambiguous, and after consideration of the occasion and necessity for the PHRA, its goals and objects, and the consequences of including minority tolling as part of the equitable tolling, the PHRA's limitation period may be tolled during a child's period of minority. Up next, constitutional law. Rivera v. Silbaugh was a case filed by an inmate, Rivera, at the State Correctional Institute. Rivera wrote a religious essay, sent it off for printing, and received back the original in 5 copies. SCI seized the copies because administrative policy at the prison prohibits inmates from receiving duplicate copies of publications without prior approval. As Rivera did not have approval, the copies were seized. He was afforded no relief through the internal grievance policy which resulted in this suit. The case was dismissed at the trial court as frivolous, and this appeal followed. Rivera claims on appeal that the withholding of the copies was a denial of his First Amendment rights to communicate by mail and right to free exercise of religion. The court found that seizing the copies in no way interfered with Rivera's right to communicate by mail, as he was in no way deprived of the opportunity to communicate with the outside world. The court also found that Rivera failed to demonstrate that the seizure of the documents impinged on his right to the free exercise of religion. The court stated that at most he was deprived of copies of his essay, which such a minimal intrusion fails to constitute a substantial burden on the exercise of his religious beliefs. Finally, Rivera argues that he was singled out and discriminated against as a class of one, as other similarly situated inmates were receiving copies of religious material. To allege an equal protection claim under a class of one theory, a plaintiff must show that 1. The defendant treated him differently from others similarly situated, 2. that the defendant did so intentionally, and 3, that there was no rational basis for the differences in treatment. Here, Rivera makes a bald assertion that others who were similarly situated were being treated differently, but failed to provide any factual support for his allegations. Assertions of intentional disparate treatment must be supported by specific factual allegations. As Rivera failed to plead facts sufficient to state a claim for violation of his First Amendment rights or violation of his 14th Amendment rights to equal protection, the complaint is frivolous and the order dismissing the case is affirmed. The courts addressed only 2 criminal law cases this week. Commonwealth v. Morgan is a criminal case addressing the Commonwealth's duty to exercise good faith in bringing a case to trial within 365 days from the date of filing, as required under Rule 600. In this case, the defendant was charged with escape after absconding from work release on October 10, 2008. On October 16, 2008, the Bucks County Sheriff's Office was notified that the defendant was being held in Georgia on a separate homicide and firearms charge. Bucks County sent a fax requesting that a detainer be lodged against the defendant. The defendant was convicted on involuntary manslaughter among other charges and sentenced to 10 to 20 years incarceration. He was transferred to state prison in Valdosta, Georgia to serve his sentence in July of 2010. There was no communication between Georgia and Bucks County at that time. In 2012, Bucks County sent an email requesting an update. They were advised that the defendant was serving his sentence in Georgia. Bucks County responded by indicating that the defendant still had a warrant and that they still requested the defendant be returned to Pennsylvania for trial on his escape charges. Bucks County took no further action until 2018, when they again sent another fax to Georgia requesting the detainer against the defendant. Defendant was released from his sentence in Georgia on October 15, 2018, and was taken into custody by Bucks County on October 25, 2018. The defendant filed a motion to dismiss for failing to exercise due diligence in bringing him to trial within 365 days. The trial court denied the motion and he was convicted of escape at a bench trial. This appeal followed. The court found that the minimal contacts between Bucks County and Georgia was insufficient to show due diligence in attempting to bring the trial within the required time, and therefore the judgment of sentence is vacated and the conviction is reversed. Commonwealth v. Gurung is an appeal by the Commonwealth following the trial court granting defendant's motion to suppress. The defendant was stopped for failing to use a turn signal on 2 occasions when changing lanes. The defendant filed a motion to suppress, arguing that the officer lacked probable cause to stop the vehicle. When a traffic stop is based on the observed violation of a vehicle code or an otherwise non-investigatable offense, an officer must have probable cause to make a constitutional vehicle stop. A police officer has probable cause to stop a motor vehicle if the officer observes a traffic code violation, even if it is a minor offense. Section 3334 is the statute that provides for required turn signals. The court found that reading Section 3334 as a whole supports the conclusion that the requirement to use a turn signal applies to changing lanes of traffic, as other portions of Section 3334 would be read into nothingness if the turn signal was not required when changing lanes. The Superior Court found that the trial court erred by granting the motion to suppress, and therefore the suppression order is reversed and the case is remanded for trial. We'll be right back after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple: make sure the presumed to be innocent remain innocent.
Welcome back. The second half of our show begins with 2 election law cases. In re Nomination Papers of E. Scroggin is a case that involves the election code and procedural requirements. In this case, the Green Party of Pennsylvania had submitted nomination papers for a number of candidates, including placeholder candidates for that of president and vice president. They failed to submit notarized affidavits for Scroggin and Gale, the placeholder candidates for president and vice president. After the Green Party held their convention, they sought to amend their nomination papers by replacing Scroggin with Hawkins and Gale with Walker. Objectors to the amendment argued that the Green Party candidates for president and vice president should be removed from the ballot for failure to comply with the requirements of the election code. Per the election code, in order to be duly nominated, the election code requires that a political body candidate file an affidavit of candidacy with the Commonwealth. A separate affidavit must be submitted for each candidate for office. The attempted substitution was a nullity because no affidavit of candidacy had been filed on behalf of the original candidate. The absence of an affidavit in the original nomination papers is fatal to the nomination of the replacement candidate. Also addressed in the case is whether an affidavit may be submitted by fax. The court found that when a nomination paper is presented to the Secretary of the Commonwealth, it is the duty of the officer receiving said nomination paper to examine it for material errors or defects apparent on the face thereof, or on the face of appended or accompanying affidavits. The faxed affidavit is insufficient to supply the indicia of reliability necessary. Because neither original placeholder candidate had a proper affidavit submitted, neither replacement candidate could be properly substituted in the nomination. Therefore, the Green Party candidates for president and vice president must be struck from the ballot. In the case of the Pennsylvania Democratic Party versus Boockvar et al., the Pennsylvania Democratic Party filed an action seeking declaratory and injunctive relief on a number of election issues to be addressed prior to the November general election. In addressing the election code, the Supreme Court noted that in the Commonwealth, elections shall be free and equal, and no power, civil or military, shall at any time interfere to prevent the free exercise of the right of suffrage. There were 5 counts raised. In count 1, the petitioner requested declaratory relief to provide for secure, easily accessible locations, including mobile or temporary collection sites or drop boxes, for the collection of mail-in ballots. The court found that there is no specific language in the election code limiting the county boards of election from accepting delivery of mail-in votes solely at their primary office address, and therefore, the Supreme Court grants declaratory relief, allowing county election boards to collect mail-in ballots at locations other than their primary office, and allows the use of drop boxes for collecting ballots. In count 2, petitioner sought an injunction to lift the deadline in the election code to allow any ballot postmarked by 8 p.m. on election night to be counted if received by November 10th, which is the deadline for ballots to be received under the Federal Uniformed and Overseas Absentee Voting Act. The United States Postal Service General Counsel provided a letter outlining the current timeframes for receiving and delivering mail. In light of the current state of affairs, particularly concerning the global pandemic, the court found that a temporary extension of the election code's received by deadline is necessary for the upcoming election to ensure a free and equal election. The court specifically stated that while it may be feasible to meet the election deadlines under normal circumstances, it will fail under the strain of COVID-19 and the 2020 presidential election, which would result in the disenfranchisement of voters. The court granted a 3-day extension, thereby allowing any ballots postmarked by 8 p.m. on Election Day to be counted if received by November 6th. In count 3, petitioner requests an injunction requiring boards to notify electors of defects in their ballots and allow the elector an opportunity to cure the defect. The court found that the election code does not require a notice and opportunity to cure a ballot that is defective, and petitioner failed to cite any constitutional or statutory basis that would allow the courts to impose such a restriction. While the Constitution mandates that elections be free and equal, it leaves the task of effectuating that mandate to the legislature. As the requirement is not provided for, the court denies injunctive relief on count 3. In count 4, the petitioner seeks declaratory relief that the board must count ballots that electors fail to place in the secrecy envelope. Upon careful examination of the statutory text, the court concluded that the legislator intended for the secrecy envelope to be mandatory. The failure to place the ballot in the secrecy envelope is not inconsequential as suggested by the petitioner. The provisions of the election code make clear the General Assembly's intention that during the collecting and canvassing processes, when the outer envelope in which the ballot arrived is unsealed and the sealed ballot removed, it should not be readily apparent who the elector is, which party he or she affiliates, and for whom the elector has voted. Therefore, the court declines to grant declaratory relief and will not allow ballots not placed in the secrecy envelope to be counted. In the final count, the petitioner sought a declaration that the election code's poll watcher residency requirement does not violate the U.S. Constitution nor the Pennsylvania Constitution. In examining the constitutionality of the poll watcher residency requirement, the court found that it imposes no burden on one's constitutional right to vote and accordingly requires only a showing that a rational basis exists. Given that the General Assembly chose a county-based scheme for conducting elections, it is reasonable that the legislature would require poll watchers who serve within the various counties of the state to be residents of the counties in which they serve. As a rational basis exists, the court finds the poll watcher residency requirements are not unconstitutional. The final 2 cases of the week are family law. In a child dependency case, the appeal of T.M. et al., the guardian ad litem of 6 minor children appeals a termination of a dependency case. In this case, mother and father were under orders of the dependency court following concerns regarding the children's lack of supervision, hygiene, school performance, behavioral issues, developmental delays, mental health needs, and unsanitary conditions in the home. Mother and father complied with orders and showed improvement for a time, but then ultimately absconded with the children, taking them from Pennsylvania to various campgrounds across the country in an RV. After being unable to successfully locate or make contact with mother and father, the juvenile court terminated the dependency case. The guardian ad litem requested that rather than terminating the case, custody be transferred from parents to children and youth so that a warrant could be issued to bring the children back and provide them with necessary services. The court declined to do so, stating that such a move would likely result in trauma to the children, and that is counter to the purposes of dependency court, which is designed to look out for the best interests of the children. Further, that while the court could not determine whether the children were in school, there was no indication that the children were unsafe or that their physical, mental, or moral welfare was endangered. The Superior Court found no abuse of discretion and upheld the juvenile court's order terminating the dependency case. M.E.W. versus W.L.W. is a child support case addressing support needs of an adult but permanently disabled child. When mother and father divorced, as part of the marriage settlement, an alimony payment of $800 per month was ordered to provide for support of the disabled child. Through the next several years, there were several modified support orders as the marriage produced 2 other children. Upon emancipation of the 2 younger children, there was a final support order issued which set the support amount for the disabled adult child at $0. This amount was calculated by taking into consideration the child's assets as well as offsetting father's income based on a promissory note that he owed. The court found that child's assets, in addition to a fixed and unusual loan obligation, completely offset father's support obligation. Mother filed a request for a hearing de novo to modify the support orders. Father filed a counterclaim arguing that mother could not file for modification due to collateral estoppel. The court dismissed mother's petition, finding that the previous court calculations were appropriate, and mother appealed. The court found that the trial court erred in considering child's assets in the support calculation. Per the law, a child's assets should only be taken into account when the parent is unable to provide support. That is not the case here, as father has an income of $600,000 per year. Further, the court found that SSI and disability payments to a disabled adult child should only be considered as a basis for deviating from support guidelines when necessary to avoid an unjust or inappropriate result. Again, that is not the case here. The court also found that the trial court erred by using a loan repayment obligation to effect a downward deviation from father's support obligation. The court found that the rate stated by father, the repayment represented approximately 25% of father's income with a projected payoff date under 7 years, and was by no means unusual by contemporary borrowing standards. For this reason, father's loan fails to qualify as a fixed and unusual obligation to justify a downward deviation. The last issue addressed is whether mother is collaterally estopped, meaning barred by previous litigation, from seeking a modification of the support order. The court found that the right to child support is a right of the child, not the mother or father, and it cannot be bargained away, nor can it be extinguished by principles of estoppel. Therefore, as child still has support needs, mother is not collaterally estopped from seeking a modification of the support order. The court vacates the support order entered at the trial court level and remands for a calculation of support obligations consistent with this decision. Thank you for joining us for episode 14. Go out there and have a fantastic week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.